months on ad hoc basis on such fresh terms as the state government may impose. And further observe that thereafter, none of the said incumbents will continue. In compliance of the aforesaid order dated 29/3/2017 and order dated 14/12/2017 of the Honorable Supreme Court of India, the service tenure of the teachers who were appointed as graduate teachers, as in the list enclosed in Annexure A, whose selection has been set aside, shall come to an end on 31st December 2017. And now, therefore, in compliance of the order dated 14/12/2017, the teachers whose names are listed in Annexure A are hereby appointed as graduate teachers on ad hoc basis with effect from 1/1/2018 for a period of 6 months on existing pay scale plus other allowances and entitlements admissible as per rule. The graduate teachers who are appointed on ad hoc basis will work in their present place of posting. My Lord, my initial statement, submission before your Lordship, respective submission that this judgment does not mention my name, and despite specific request, despite specific averment that I am not a party, there is no explanation, or in the order itself, there is no explanation that I was a party. So my humble submission is that this judgment I support, Tanmani's judgment I support. Supreme Court, Honorable Supreme Court judgment I do support. Nowhere it has been stated that the state respondent, executive government, has been given the liberty to violate the principle of natural justice. Constitution bans judgments that everybody should be heard before you condemn them, punish them. Maneka Gandhi, and I shall refer to the judgments later on your Lordship. Not only this, my Lord, kindly see in what is the contention. I'm now from the petition, I'm reading your Lordship. In paragraph 1 itself, I raised this question. Substantial question of law is the issue involved in this petition. Whether the termination order being numbered such and such dated 23/12/2017 from his regular appointment, Annexure 5, just I read your Lordship, and termination memo number such and such dated 31/3/2020. That means after the completion of ad hoc period, that is the date, issued by the Additional Secretary, Government of Tripura, Education School Department, Annexure 11A, without serving any notice, without hearing the petitioner, and without supplying any copy of any inquiry report or copy of judgment, inviting representation from the petitioner, is violative of principle of natural justice, violative of Article 14, 16, it is not 10, my Lord, 21, and violative of Article 311(2) of the Constitution of India, and as such, same is liable to be quashed and set aside. There is single most constitutional questions, and my Lord, I'm sorry to mention, despite 4 or 5 adjournments in the writ petition hearing, no counter was filed. On some occasions, there took the time, we shall file. They have not filed. The presumption shall be taken by your Lordship. They have no say on this. Go. Even, my Lord, despite the notification that before 3 days the notes shall be exchanged, the petitioner has exchanged, submitted copies and supplying copy to the other side, government state side. Today, at 10:30, I have received their short note, my Lord. And I'm relying upon that, my Lord. It is also not a single word about this contention. there is some preliminary objection, there is some other contention that Supreme Court said this, that thing, service is violative of some rules, etc. My lord, that is a bigger question, my lord. Can they show or claim that in any of the judgments of Tanmanyat or by the SLPC, which has affirmed the judgment of the Tanmanyat, has said you should not follow the principle of natural justice? It is not a single line. It is presumed that you have given a power to do something, you shall do it in accordance with law. They are not the monarch. Rule of law is the constitutional law of the country, your lordship. They must follow the law, constitutional law rather. My lord, it is known to everybody, your lordship. I'm just reading, my lord, what is constitution. In Article 21, my lord, it is very clearly, I'm reading, my lord, for my own satisfaction, Article 21. Protection of life and personal liberty. No person shall be deprived of his life or personal liberty except according to procedure established by law. That is the constitutional right. And my lord, in Maneka Gandhi versus Union of India, it has been in a landmark judgment in India, your lordship. In more than 3,900 subsequent cases that has been referred, there must be one rule. This Orivoltarian party must be followed. And that procedure to follow hearing process should be reasonable, should be fair, that should not be unfair. My lord, if I can submit in this way that suppression of facts, I should show just now, your lordship, I have claimed, I have not seen any paper that I am included. Rather, in the writ petition, it is there, I will show that Supreme Court on my RTA application has informed I am not a party in the SLPC before the Honorable Supreme Court. How can they say I am covered? In some cases, they say that my case is covered because there was one newspaper advertisement. My lord, you will be astonished to see, your lordship, that I have said that if there is in paragraph 14, running page 11 in the writ petition, your lordship, they are suppressing. Why, your lordship? If that is their case, that the respondents have never supplied any copy of any advertisement published in any newspaper by which the petitioner has been noticed and made a party in WPC number 51 of 2015 and SLPC number such and such. It is actually my common group of 58 writ petitions, and it is parties means petitioners and respondents were 914, and in the process about 10,000 plus teachers have been employed. I am not only saying for me, my lord, all those who have, it is a fundamental right, everybody can submit, my lord. I humbly submit to allow this one line outside the petitioner's interest also. All the petitioners, those who were the parties, either petitioner or respondent, they are also entitled to get this Orivoltarian party right. That cannot be taken away. That is the constitution bench decided by our country, Honorable Supreme Court of India. Nobody can ignore it. That will be a conflict. There is one fear, or it is shown to everybody that as per judgment, you have been terminated. Let them show that I am a party. Let them show that in any manner, Supreme Court has said, Article 20, Article 14, that fair procedure of hearing should be dispensed with. Not a single word. Even in today's short note I have received, it is not there. They are not changing that part. They are not saying that I am not entitled to get Article 14 right of fair hearing, reasonable hearing. It is not their case. Their case are only technical. They are parties who have said only bureaucrats, my lord. If I can say in this way, bureaucrats will not give the interpretation of the law or judgments. Your lordship will give. And I'm satisfied, grateful, your lordship is hearing in a full bench to decide the law. This is the Supreme Court for us, for the petitioner's lordship. We cannot go, 10,000 people cannot go. But this will do a social justice. This will, I'm sorry, my lord, I'm getting maybe I am tense. So, my lord, that is my first case is there. Maneka Gandhi, I will show my lord. And their suppression, they have not, why they have not filed any counter despite 4 or 5 adjournments, despite taking time on some occasion, because they have to disclose this thing. They have not preferred to disclose this thing. So I am not coming to the, according to my learning, my lord, that inch centimeter issues I am not taking. I am raising this fundamental broad question that I cannot be deprived of. My lord, now I am coming to that, my lord. There is, what is that? They can say they have followed some procedure. Then they have to submit, disclose the what procedure they have followed. They have not followed. I applied under RT Act. They have not. They have not disclosed anything, my lord. Can you see, my lord, in note, my lord? It is subsequent. With your kind permission, kindly, your worship, kindly see the last document in volume 2 of 3 documents, my lord. Even on 25/8/2023, I applied in the volume 2, that is page 284, last one. Please. No, it is the bigger one, a spiral binding. Volume 2, it is written. Volume 2 of 3 within bracket documents. Yes, your lordship.
Page 284.
284, lordship. To the Director of Secondary Education, Government of Tripura, Agartala. Request to supply information and documents for submission before the Honorable High Court of Tripura. Petitioner, graduate teacher, Ishanpur Higher Secondary School, terminated. So I submitted this application. Sir, with due respect, I would request you to kindly supply me the following information and documents for submission of the same before the Honorable High Court. 1. Please inform whether there is any government rule or guideline which have been followed by you for consideration of the common judgment of the Honorable High Court of Tripura in case number WPC 51 of 2014, Tanmoy Nath versus State of Tripura and others, 58 petitions disposed of on 7/5/2014, affirmed by the Honorable Supreme Court of India in SLPC 18,993 to 19,049 of 2014, disposed of on 29/3/2017, before issuing my termination letter number such and such dated 23/12/2017, issued by the Director of Secondary Education Tripura, and subsequent termination orders. Please answer yes or no. No reply has been provided, Your Worship. Number 2, if the answer to the above question 1 is yes, please supply to me authenticated true copies of the rules or guidelines. No reply, Your Lordship, nothing has been supplied. Number 3, please supply to me authenticated true copies of all file notes in connection with my termination orders from the stage of receiving judgment of the Honorable High Court of Tripura in case number such and such, Tanmoy Nath versus State of Tripura and others 58 writ petition disposed of the such and such and affirmed by Honorable Supreme Court of India in SLPC number such and such disposed of on 29/3/2017. Before issuing my termination letter number such and such dated 23/12/2017, issued by the Director of Secondary Education Tripura and subsequent termination orders. And urgently so that I can submit the document before the Honorable High Court of Tripura for consideration in a writ petition challenging my termination order. Please supply me the documents and information as my life and livelihood issue is involved in this matter. They do not think, my lord, it should be supplied. They do not think that rule is to be followed. They do not think that Honorable Supreme Court Constitution bench decisions are to be honored. It is an arrogance, my lord, in the administration. It is an arrogance, man. Nothing.
Yes.
Your Lordship, I'm in between my submissions on my issues. I'm referring the judgment. If you may kindly pardon me. In Maneka Gandhi, reported in air 1978 SC 597. May I read, my lord? There are 57 and 58, my lord. I'm reading 58. We may commence the discussion of this question with a few general observations to emphasize the increasing importance of natural justice in the field of administrative law. Natural justice is a great in para 58 of air, you know, My lord, should I read the entire paragraph 58, your lordship? Because this is the beginning of a landmark era of natural justice, for you order and pardon by the judgment delivered in Maneka Gandhi versus India, your lordship.
With all due respect and humility, the ratio of Maneka Gandhi's judgment, well known to you and well known to us also, was arising from a passport.
My lord.
Post-decisional hearing in passport matter could not have said. The apex court then said Article 14, 19, 21, all of them are linked together and gave that. The case before us
My lord.
is one in which an entire selection process has been set aside concerning teachers, because the revised employment policy itself, under which the selection process was done, was found to be in teeth of several constitutional provisions, 16, and also suffered from lack of guidelines, discretion, untrammeled. And it is not that individual cases were commented upon. Individual cases were cited as examples as to how application of the different yardsticks of the revised employment policy has resulted and could have resulted more in illegality, arbitrary. So the court did not comment upon individual matters in that way. The whole process was in jeopardy or was vulnerable because the revised employment policy of 2003 was held to be ultra-violent. Now, that issue actually has spanned about last. The first challenge was in 2011. So now we are in 2023 September. 12 years it has spanned. You got an order of termination in 2017 December. Your services were terminated in December 2017 by an exchequer file. There was no indication in that order that your services have been extended. For 6 months on ad hoc period. So, for all practical purposes and legally speaking, your employment had come to an end in 2017. You were conscious of that. Now, when the extension period of ad hoc service has come to an end, and that extended period is only because of the interim orders passed by the apex court from time to time. All those who were beneficiaries of that selection process under the revised employment policy, under that 2009 advertisement, all have gone out of service, except that there are certain riders that they may face fresh selection process, there will be age relaxation, etc., etc. Now, at this stage, for you to contend that individual petition of individual employees had to be given a notice and an opportunity of hearing, this is too late in the day to ask for. It was a litigation journey in which the whole lot of teachers were involved, whole lot of state agencies were involved. Very decisive judgment was given in 2014 and 2014 or 17, 2014. Now you are asking for principles of natural justice. When a judgment operates in rem to all those who are beneficiaries of that issue, can individual person say that I should have also been made a party and I should have been given a right of hearing? And if that be so also, this issue was again addressed in that Vijay Krishna case, judgment of 3rd October 2009. That whether those persons were meditating and they were sitting, they were fully aware that their employment has come to an end. Is it not too late in the day it is difficult for not only the employer, but also our court to say something beyond what the apex court has said in its final order. It has upheld the judgment, except that particular paragraph has been clarified.
May I answer? Because it is a very pertinent question, I must satisfy your lordship. My lord, all these judgments will come later on. Firstly, kindly see my on the question of delay in paragraph 20 of the writ petition. I have explained this thing.
Annexure 1.
No, I am reading my lord paragraph 20 of the writ petition, running page 12, 1-2.
Yes, just one more. This annexure 1, which is an appointment letter of 25th March 2010. This employment or appointment letter arises out of the same selection exercise.
My lord, all are not, my lord, because I am also not directly under employment policy, my lord, which is a, in any way it can be said it is an affirmative policy of the cabinet government, in legislative government. They were to executive government.
I put a very simple question, that this appointment letter arises out of the selection process under the same advertisement.
Same advertisement, your lordship.
You have not stated in your paragraph.
My lord, I have stated that due to advertisement, after advertisement, I have been.
That advertisement date should have been mentioned. That's some 2009.
Maybe there is many lacunas may be there, my lord, but I have taken up the broad issue. My lord, I want to read paragraph 20 of the writ petition in the running page 12. Delay I have explained this way, lordship, because I know that may come. That although there is no limitation, in filing a writ petition, as a matter of explanation, the petitioner submits that the first termination order was issued on 23/12/2017. He submitted his representation on 30/12/2017. I submitted representation, no response. Lastly, 2 termination orders have been issued on 31/3/2020. That it is a case of 2020. He was on ad hoc service and getting salary to earn livelihood for his 5 family members. Lastly, the petitioner, in response to his RTA application, learned from the communication dated 22/9/2021. Only last I have learned from that time that I am not a party. They are claiming this thing, my lord. From the communication dated 22/9/2021, issued by the Assistant Registrar, Supreme Court of India, New Delhi, there the petitioner was not a party in the SLPC number such and such, State of Tripura versus Sri Karmoynath, which were dismissed on 29/3/2017. Thereafter, the petitioner has gone to school. I have gone to school to resume his duties. And what? But he has been prevented from joining his duties and to work. Lastly, he has received a copy of communication dated number such and such, dated 8/9/2022, my lord. And I have filed the petition in 2020. It is not delayed.
You were not on the point of delay. You were not on the point of delay. We were on the point that termination of the employment of all the beneficiaries of that selection exercise came.
I respectfully ask, interrupt your lordship. Suppose, my lord, I am in a temple of justice. In this temple, I have been punished. So, and suppose I am Ram. The executors have punished me, but punishment is against Duryodhana. Duryodhana has not been executed. I am executed. Is this permissible? It is not permissible. I am giving one example, your lordship. That is why notice is a must. Suppose I am Ram. Punishment order is against Duryodhana. They must punish Duryodhana only. They are punishing Ram also. Therefore,
there is an undertaking before the Honorable Supreme Court after that cutoff date of 1st March 2020. that is reflected in the order dated one order is of 1st November 2018, paragraph 4. Having considered the matter by a bench presided over by Honorable the Chief Justice, Justice Lalit and Justice K.M. Joseph. Paragraph 4. Having considered the matter, we are of the view that at this stage we ought to permit the state of Tripura to continue to avail of the services of the terminated teachers until the end of the academic session 2020, meaning the academic session 2019-20. 1920 obviously ends on 31st March 2020. The above direction has been issued in the peculiar facts of the case and the circumstances which have confronted the state of Tripura, and above all, the need of the functioning of teaching activities in schools in the state of Tripura remains unaffected. This is the observation of the apex court upon the undertaking given by the state of Tripura. There is another order of 19 June 2020. Mr. Maninder Singh, learned senior advocate appearing for the state, submitted that after the end of the academic session 2019-20, the concerned teachers have ceased to be in employment, that some of the teachers had participated in the selection and the state had afforded them age relaxation. He also submitted that the state government is contemplating to accommodate some of the teachers in alternate employment. So this is what has been told or stated on affidavit before the apex court.
My respectful submission, my lord. It is for the parties, those who were respondents or petitioners in the writ petition.
There lies perhaps the misunderstanding on the part of the petitioner that he is not covered by this this litigation or this judgment which has been delivered.
My lord, let me then complete my argument, and your lordship will decide. We have full faith about this wiser brain of this Honorable High Court. So we are bound by that because I have said it is the Supreme Court to us, my lord. Well, this is the case. I am relying upon principle of odi alteram, principle of natural justice. No hearing, no notice. I am taking the MD ECIL case, 1994. That is also a reference case. Two benches had two views. Whether while after the inquiry is completed, that should be supplied or not, or instantly it should be punished on the basis of that. Then, my lord,
But that won't be applicable in your case.
on service, my lord, right? But the decision is not I'm taking the ratio. Ratio is that if they have relied upon something, if they have taken opinion from someone, I have not unclosed anything, my lord. It is in the public domain.
Please understand, there is a distinction in the two sets of circumstances. One is a dismissal or a removal on a charge against an individual employee because of some misconduct. And there, the whole process of disciplinary proceeding and service of notice, framing of charge, witness, framing of second show cause notice, etc., is contemplated. But it is not the case of anyone that your petitioner or any one of those 10,000, 11,000, 12,000 teachers, they had misconducted themselves. The appointing authority had done something which was ultra vires the constitution. So that whole process had to go. It is not that you have been asked to explain as to why your employment should be preserved because you have a difference to say that. Probably the teachers were innocent victims of that.
No, my lord, that has been protected under by paragraph 127, my lord. I shall come later on to that part.
Yes,
when entire selection is stinking, is conceived in fraud, delivered in deceit, individual innocence has no place, and the entire selection process should be set aside. This is what had happened in this case. Individual notice issue, your main case is that notice has, I have not received any notice. I was not included in the petition, so this judgment will not be acted upon me. This is your main submission. You know the exception to natural justice, the rule of natural justice.
Yes, Your
What is
Lordship.
the exception to rule of?
Your Lordship, I assert, it is, I am entitled to, I assert, Your Lordship. Most respectfully, I assert, Your Lordship. It is the most fundamental.
Selection is set aside, is bad in law, arbitrary, actuated with malice. There is
My
a
lord.
question of
My lord,
following of principles of natural
my
justice.
lord, my lord. They have not said in the order, in the termination order, in Annexure 5.
What they say.
My lord, if you say so, I have no answer.
Ask.
I have no answer, my lord, my lord.
This is the answer you are.
Your Lordship, Your Lordship,
The question you have to answer.
Your Lordship,
I have no answer. What does it mean?
Your Lordship.
This is the question
What
you
has
have to answer.
what has not been contended by the state executive in the order?
You are.
It cannot be brought in the affidavit or in the argument, Your Lordship.
You are on academic discussion. You are harping on the rules of natural justice.
No, my lord, I'm my livelihood, Your Lordship. I am not on academic, my lord. Kindly let me conclude that Your Lordship.
The court to be swayed by emotions
I
and.
am not, my lord, emotions on the law.
How the
Law decided by constitutional bench, Your Lordship. Kindly have some. No, my lord, I am not unnecessary, my lord. It is my right to life and right to livelihood. It is the constitution bench which has emboldened me. Not only this, then before I submit other, I can refer two things, Your Lordship. Kindly see, this
You are unlawfully benefited.
my lord, see, even after whether the question is now, I am showing, my lord, and kindly
Mr. Saha,
submit.
it is very difficult to identify the persons unlawfully benefited
My lord,
and the persons
No, my lord,
wrongfully
no, my
deprived
lord.
of.
it is a one view, Lord.
So in
I
this
respect me, my lord. I respect my.
exception to rule
This is one view, Your Lordship.
natural justice.
I respect one view, Your Lordship. My view is there. Even if, suppose, my lord, even if there is one judgment by naming me, kindly let me say. Suppose in the judgment it has been indicated that Ram should be terminated. Even then, Ram is entitled to get one notice. Well, I am showing one judgment of this Honorable High Court in Division Bench. Kindly see, my lord, in volume 1, at page, my lord, 399. My lord, it is in this Honorable High Court, single bench, then affirmed by division bench that, oh my lord, after 22 years, I got the benefit.
Relying upon that judgment, us to appreciate that, because that judgment obviously is a judgment of a division bench of this court.
My lord.
Here is a matter which has attained finality up to the apex court.
And my interpretation is that Honorable Apex Court has supported my contention because it has not named me. They have given, you do according to law. According to law means following the principle of natural justice, allowing me that opportunity, my lord.
This judgment doesn't say that do it again in accordance with law.
It has not said that they can violate law. Is it required, my lord? Not, my lord. Everything will not be written that you have to do according to law.
Please appreciate, you see, you may be harping a point of argument or a line of reasoning from which you have built up your case. But it's also equally important to appreciate the contrary point of view. That this is a case where it is not that individual employees have been handpicked to terminate their employment. It is a case of mass termination of employees because the whole employment process was vitiated due to revised employment policy being ultra-violent.
My respectful, humble submission is there. Admitting everything as it is, my lord. Everything admitting. In paragraph 127 of the judgment, my lord, I am referring again. Can you see, my lord? In volume 1 of 3, my lord, can you see, my lord? Paragraph 127.
Is it para
Please.
157 which is creating?
Yes, my lord. My lord, let me explain that, because I can expand that thing, because I have done some research works on this matter, my lord. That is why I am assertively submitting.
Before you make your effort, let us
Okay, my lord. Kindly help me, my lord,
let
to assist your lordship.
let us indicate the understanding of para.
Yes, your lordship.
127.
In
It has appeared been explained also.
paragraph 127 at page 217, I think. I'm reading it. Where is that? Paragraph 127.
Para, Mr. Saab, please.
127.
Hear us. Para
Yes.
127 is.
Running page 217, paragraph 127.
Yes.
My lord. Since we have set aside revised employment policy, which applies to a large category of post and not merely to teachers, we would like to make it clear that our judgment shall be prospective in nature and shall not affect the appointments already made unless the said appointments are already under challenge before the court on the ground that employment policy is illegal. So my employment has not been challenged, my lord. My lord, I pause and refer another thing. In this case, I am saved. If your lordship interpret this in my favor. Supreme Court has also affirmed this judgment in 2-2. That means including this 127. What is this, man?
What is this? We will explain to you. Before you labor, because we have also applied our mind, gone through the same judgment time and again, in fact. More than me, brothers have gone.
Yes, submit one more,
Got a
one more line here.
Deal with it.
My lord, this is the prospective of our ruling.
No, please understand. Here, in the case of Tanmay Nath, the entire employment of undergraduate, graduate, postgraduate teachers under a particular advertisement totaling about 10,000 or whatever, under the revised employment policy was in question. The learned division bench of this court held that the policy itself was bad, therefore all appointments had to go. Then, very wisely, at that stage, the learned court must have felt that since the revised employment policy is bad, declared by us, the recruitment, please listen carefully, the recruitment may not be restricted to only teachers in the last 10 years. There might be several appointments in several other departments of the government, which, because of this ultra-virus ruling, if we do not clarify that it would be prospective in nature, then all those employments undertaken since 2003 till 2014 would be vulnerable and they would be set aside. They would be revoked by the employer, or somebody will come and challenge, some unsuccessful candidate will come and challenge here. Therefore, they said that this will be prospective in nature unless there is the said appointments are already under challenge within the court on the ground that the employment policy is illegal. So anyone coming in future will not get the benefit. But if there is already a challenge, then that will be determined as per the ratio of this judgment. So that is how 127 clarifies that prospective overruling is prospective and concerning all other employments, not the same set of employees.
My lord.
So let us not add to the confusion. It has a very long litigation journey.
My lord. If there are two views, my lord, if there are two views, possible two views.
No two views are possible now because this has been upheld by the apex court.
Therefore, it is supporting me. Therefore, my lord, because neither Honorable High Court nor the Honorable Apex Court has said that I should be terminated without serving any notice, or that protection of prospective of our ruling is not applicable to me.
This notice part anyway is not here, neither here nor
My
here.
lord, my lord.
But even if you say that 127 has been affirmed by the apex court, the meaning of para 127 would remain the same.
My lord. I'm
The entire interim orders of the apex court for extending the ad hoc services are only concerning the beneficiaries of this employment. Teachers. That in that case, Tanmay Nath's case, there was a notice by paper publication by the order dated 6th February 2014.
Has it been disclosed, Your Worship? No, I have applied.
Vijay Krishna has taken note of it.
They have not supplied it to me. I have shown in paragraph 15.
This argument won't.
They have not.
It's a notice to the public at large and those who are going to be affected by this litigation exercise.
Under order 1 ruling.
Order 1 ruling.
At least the notice is to be brought before Your Lordship.
Those arguments in a full bench don't please.
My Lord, that has not been placed on record, my Lord. And my Lord, under CPC, my Lord, that by paper publication, one government employee cannot be implemented and adversely affected. That is my humble submission.
Order 1 ruling. Have you read this
My
provision?
Lord. My Lord. It is
Now tell us about order 1 ruling.
And what I have,
Reading of order 1.
my Lord,
What it contemplates.
my Lord. Let us submit, my Lord. Should we submit, my Lord?
Was a notice under order 1 ruling.
My Lord, I am not covered by anything. They have not served any notice. Let them sub one notice. My Lord. Again, that is, my Lord. Let me submit, my Lord. Let me submit, my Lord. I am before Your Lordship, because I am without my livelihood. And my Lord, what is para 127? My humble understanding is that it is the.
That is why you have relied upon that payment dwellers case. That's right.
Now, kindly let me submit one thing. My Lord, kindly let me submit one thing, my Lord. That prospective overruling is not that it is from the sky that we added. It is the doctrine of prospective overruling as developed in So that is our constitution bans, Your Lordship. How can it be interpreted otherwise, my Lord? Suppose in a policy matter, lakhs of people have been given some benefit, it will be always prospective, my Lord.
Difficulty, Mr. Saha, is that the findings, the ratio, everything concerning this employment has attained finality because it was carried in appeal and Supreme Court affirmed it. And in fact, gave a deadline, end of academic year 2019. That is how you also continued till then.
My Lord.
If you were wise enough, maybe you could have raised all these arguments before the apex court by filing an interlocutory miscellaneous application. That I have not been made a party, I have not got a paper publication notice, I should be given an opportunity. All that is lost now.
Your Lordship. If the constitutional bench judgments are not taken into account by Your Lordship, then as a common man, as a common citizen, where shall I go, Your Lordship? And what will be the loss of the state administration?
Principle of finality.
Yes, my Lord. Yes, my Lord.
Finality of litigation.
If one can,
It
so
will suffer from constructive res judicata.
my Lord, let me complete in that case. I complete, my Lord. Let me
Complete.
in this is a para 127 has been relied upon by this Honorable High Court in WPC 119 of 2020. Another more than one case. One reason is WPC 119 of 2020. It has been followed and benefit has been given. And another case also, WBC 797 of 2020. In two cases, this has been relied upon. Therefore, and in some other cases, notice also has been given back. That it is not that I am claiming only alone. This notice was not served upon a particular person, and this has been allowed by lordship. Therefore, it is not I am submitting alone. Not that earlier this question has not been considered by this honorable. Notice has been not only this, and even the state respondents also have issued notice upon some persons, your lordship, and that has been quashed by your lordship, by this honorable High Court. Then Article 14 comes, your lordship. It cannot be that they will pick and choose against some person, they will serve notice. And my lord, in my volume 2 of 2, I have enclosed list of several hundreds people, those who are serving, those who were RTI application, it was disclosed that under 2003 employment policy, persons in different departments, in the education department, from my lord, on the first page of the index, bottom last one, information supplied by secondary education in volume 2 of 3, your lordship. Then department, law department, then Directorate of Fire and Emergency Department, Food Department, Police Department, Forest Department, Information and Cultural Affairs Department, Youth, Sports and Youth Affairs Department, Animal Resource Department, Industries and Commerce Department, Elementary Department showing appointments made under recruitment policy, information supplied by higher education department, appointments made under recruitment policy 2003. Again, application, or that is my application. So all these are there that hundreds and thousands of people are serving, some of the education department also. My lord, this is a case where there is a gross discrimination, gross disregard to the Constitution bench judgments.
We have taken your point of natural justice. We have thought aloud about how we have taken it. So you can now move on to another.
Okay,
Also,
One thing, my lord.
we have taken note of.
Yes, ma'am. One thing, my lord, just that recently in the volume 3 of 3, I have referred on this. This. Yes, it is here. It is. HL 1989, volume 1, SCC.
Relying upon some decisions on what proposition,
My lord, suppose your lordship decides, okay, I shall receive one notice now. My humble submission is that this order is a void, not voidable, because it is illegally served upon me. So on the basis of this judgment, that I am reading, my lord, paragraph 12.
It's a full benefit.
In our opinion, the post decisional opportunity. I'm reading from Monopoly University. In our
Line on which paragraphs you need to make the